Hello everyone. So today in this video, I would be discussing the definition of International Commercial Arbitration, which is ICA, under the Arbitration and Conciliations Act in India. I'll be calling it A&C Act from here on onwards. So you must be thinking that the definition of ICA or International Commercial Arbitration is already there in Section 21F of the ANC Act. So why do we need to dive into this question furthermore? Or is this issue any deeper than the mere interpretation of that definition provided in the Act? And the answer to that is, in fact, yes. In order to appreciate or answer this issue, we need to understand this very structure of the ANC Act. So when we look at the ANC Act, there are two parts, Part 1 and Part 2, which essentially talk about arbitration. Now, a simple thumb rule to understand to which arbitrations Part 1 would apply and to which arbitrations Part 2 would apply, a simple thumb rule can be figuring out the seat of the arbitration. So whenever you find out or you conclude that seat of arbitration is in fact in India, it is Part 1 of the A&C Act that would be applicable. And if you come to a conclusion that the seat of the arbitration is anywhere else other than India, then you can simply conclude that it is Part 2 of the ANC Act which would apply. Now, why do we have this distinction? That question must be arising in your mind. So, in order to answer that, we can broadly say that any provisions relating to an arbitration, on the whole or holistically, provide for following matters. And those following matters are, do pardon my handwriting here, commencement of the arbitration, conduct of the arbitration, challenge of the award, and recognition and enforcement of the arbitration award. So, on the whole, we can say that any provision or any legal framework which would talk about or which would regulate an arbitration process could, on the whole, provide about these four features. Now, when we look at these features, we find out the first one is commencement of arbitration. So, these provisions would talk about how to begin an arbitration, when to start, when to send out a notice of arbitration, how to figure out whether there's an arbitration agreement to begin with, how to file an application before the court to refer a civil suit to arbitration, how to file an application and before which court for appointment of the arbitrators, so on and so forth. So, all the matters relating to the pre-arbitral phase could be governed by these provisions. The second aspect is the conduct of the arbitral proceedings, how to file the statement of claims or defense during the proceedings, what principles should be observed in an arbitral tribunal, which is principle of party autonomy, principle of equality, etc. How to approach a court for evidence related issues, so on and so forth. So everything which comes up, how to file for interim reliefs when your arbitration has already begun. So everything that comes up, all the issues that might come up during an arbitral process might be governed by these legal provisions. The third one is challenging of an award. Now imagine that you've started an arbitration, you've conducted an arbitration, and in the end you have an award with the parties. There's an award debtor in the picture and there's an award creditor in the picture. The award creditor is supposedly the winning party, who is now owed the money or the sum decided in the award. And the debtor in the picture, the award debtor, is the party who lost and who now owes money to the award creditor. So, one of the options with the award debtor is to take the award to the court and challenge it on certain grounds, right? Now, what these grounds are and what is the consequence of a successfully challenging an award, which is essentially holding that award null and void, we will discuss it in another video. So, all of these matters might also be governed by this legal framework that we are talking about. So, this is again post your arbitral proceedings. And then we come to the fourth step. This is and this fourth step might happen right after the third step, or also in certain cases simultaneous to the third step, which is your setting aside or your challenge proceedings might already be going on, and you might be seeking enforcement in one of the courts. Now, in this fourth point, your award creditor, the one who is owed money now at this stage because they had award in their favor, they might go to a court of law and they might enforce that award and would want to sort of uh, enforce that award and would sort of take out the sum that they're owed from the assets of award debtor, right? So they might now raise claims against the assets of the award debtor. So all of that proceeding, which court they might go to, what are the grounds on which enforcement can be resisted, etc. All of this is also provided by your legal framework related to arbitration. So we can say that this is also sort of post arbitral proceeding uh, phase. So on the whole, I hope you're able to appreciate that on the whole, these are the four phases which any law relating to arbitration might be regulating. Now let's come back to our point. We figured out that if the seat is in India, it's part 1 which would apply, and if seat is anywhere else in India, it's part 2 which would apply, right? Part 1 of the ANC Act provides law or framework on all of these four matters. So once your arbitration is seated in India, part 1 would inevitably be applicable. And this would mean that all the provisions given in part 1, and part 1 does contain all the provision related to all of these 4 points that I've written, they would regulate commencement, conduct, challenge, recognition, and enforcement of an award. Right? So part 1 framework provides about all of these four things, and hence they would be applicable to any arbitration seated in India. Now, what about part 2? So, we would again, I would like to discuss the laws applicable to an arbitration in another video because uh, that is a completely different topic which can have a detailed explanation and various issues arise out of that. So, whenever seat of an arbitration is outside India, wherever that seat might be, let's say that seat is in France, that seat is in Singapore, Hong Kong, US, Venezuela, wherever that seat might be, that country's or that jurisdiction's seat law, which would be, let's say, equivalent to part 1 of the ANC Act that we have here, those laws would be applicable to that arbitration, right? So our law will not interfere in an arbitration which is seated outside, right? Our law would only come into the picture to enforce those awards So part 2, which governs arbitrations seated outside India. So I would just write here that this legal framework provides all points 1, 2, 3, and 4. However, this part 2 only provides point number 4, which is recognition and enforcement of the award. So now what does it mean? So let's say an arbitration is in Paris. It's of course an arbitration seated outside India, or in other words, it's a foreign seated arbitration, right? I would just write it here, foreign seated arbitration. What does that mean? That means that our seat law, which is part 1, would not be applicable to that arbitration. So part 1, which provides for all of these 4 matters that would be inapplicable to that arbitration, we are going to stay out of that arbitration, right? And why is that? Because Paris, that is France, would have its own seat law, and that would be applicable to the arbitration, right? So we are not going to interfere in that, and part 1 would not be applicable to that, right? This was basically also the holding or the ratio of the famous Balco judgment, but I would like to discuss it in another video for sure, right? Because Balco's effect has also been sort of boiled down with the proviso of 2 subsection 2. All right. So now what does it mean? So now our part 1 would not interfere in this Paris seated arbitration, but part 2, which we have in ANC Act, would apply to this Paris seated arbitration. And what is part 2? So part 2 is essentially ratification of India, sorry, of 2 conventions, which is reflected in chapter 1 and chapter 2 of part 2. So chapter 1 reflects ratification of New York Convention, and chapter 2 reflects ratification of Geneva Convention for enforcement of foreign awards, right? Also make a note that chapter two's application, which is enforcement of a foreign award, is sort of redundant now since it has been overtaken by New York Convention, right? So again, I would like to discuss the interplay of or the functioning of these 2 chapters and how New York Convention has sort of overtaken Geneva Convention in another video because there's a completely separate explanation to that. Right. So part 2 essentially lays down provisions which are a result of India signing the New York Convention. And part 2 provides for recognition and enforcement of the award. So this Paris-seated arbitration that we talked about, let's say between A and B, if any of these parties, A and B, want to enforce the award in India, let's say B was the award creditor and A was award debtor. So throughout their arbitration, commencement, conduct, and challenge 1, 2, and 3 would be governed by the French law. However, this fourth point, which is recognition and enforcement of the award, so now B is the award creditor and he has this award that resulted out of their arbitration against A. Now, A has assets in India. So B might file an application under Part 2 of the A&C Act, which only provides for recognition and enforcement of such foreign seated arbitral awards. right? So now what will B here do? B will file an application under Part 2 of the A&C Act to enforce that arbitral award that Mr. A got in Paris because now, sorry, Mr. B got in Paris because now Mr. A's assets are in India. So he's bringing the award here, enforcing it here against and realizing his claims against A's assets in India, right? So a simple thumb rule, a simple takeaway so far is for Indian seated arbitrations, Part 1 would apply. Part 1 provides for commencement, conduct, challenge, and enforcement of the awards, commencement, conduct of the proceedings, and challenge and enforcement of the arbitral awards. If arbitration is seated anywhere outside India, then Part 2 would apply. Part 2 only provides for recognition and enforcement of the award, which is also pursuant to New York Convention and Geneva Convention. For our practice now, Geneva Convention is almost redundant. It's not used. So it's the New York Convention where we seek relief, right? I hope that makes sense. All right. So now that we have understood the structure of the A&C Act, and by structure I mean these two parts, Part 1 and Part 2. Now we need to figure out how are we defining international commercial arbitration in the A&C Act? And that should lead you to answer the follow-up question. How are we defining international commercial arbitration under these two separate parts, which is Part 1, wherein arbitration is seated in India, and Part 2, wherein arbitration is seated outside India. So the first one, where arbitration is seated out in India. Just give me 1 second. Waiting for the right slide here. All right. Great. So now we read section 2, subsection 1, F. And this section starts, this section 2, of course, provides definitions. And it starts with the qualifier which says, in this part. And when you see where section 2 is lying, it is lying in part 1 of the A&C Act. So right at the outset, the definition clause begins with the wordings in this part, which is part 1 of the A&C Act, unless the context otherwise requires. Now, guys, this is beyond important because every now and then you would realize that whenever the court is contemplating the definition, the court always contemplates on this phrase, which is they read the section and they see, is the context requiring otherwise? So if you would have read the Amazon judgment, wherein the issue was, do we read emergency arbitrations in section 17 of the A&C Act? Therein as well, the court used this interpretation of this very phrase, which is unless the context otherwise require. So what does it mean? So when you see section 2 provides definitions, and before laying down definitions in detail, it requires, the qualifier says, in this part, unless the context otherwise require, you will define the terms as follows, which means that you have to read the section, you have to read the provision, and you have to see in what context that provision, what is exactly that provision is stipulating, And only if the context is correct, you will define the terms as follows. And if the context is different of the provisions, perhaps these definitions could have another meaning attached to them, right? So these section 2 definitions that we are seeing would only be applicable, and we'll only read these definitions so far as the context in the provision is same. As soon as the context changes, the definition and the meaning might also change, right? Now, what it will change to, that is up to the courts to figure out by looking at the legislative intent, the case, etc. All right, now let's see. So let's read it again. In this part, which is part one, unless the context otherwise requires, international commercial arbitration means an arbitration relating to the disputes arising out of legal relationships, whether contractual or not, considered as commercial commercial under the law in force in India, and where at least one of the parties is. So, international commercial arbitration means wherein you have a commercial disputes between two parties having a legal relationship. That commercial dispute might be arising out of a contract, or it might be uh, arising just out of the legal relationship and the commercial transaction that parties have entered into, where at least one of the parties is one, an individual who is national of or habitually resident in any country other than India, or a body corporate which is incorporated in any country other than India, or an association or body of individuals whose central management or control is exercised in any country other than India, or the government of a foreign country. Now, one thing which is common in all of these 4 points is the international or the foreign element. So, what is the definition requiring of us? So, first, it's saying that it should be a commercial dispute out of a legal relationship. All right. And then it says at least one of the parties is. So, first, it talks about individuals, then, it talks about body corporates, then, it talks about associations or body of individuals, and then it talks about the government. And in every uh, subset that we'll see, that the requirement is that there should be an international or foreign character to that, right? So, what does it mean now? So, let's take up different scenarios. So, let's say there are two individuals, both have entered into arbitration, and both are Indian. Then it would not be an international commercial arbitration, rather it would be an arbitration between two Indian parties, because none of the parties is have that international character as per the definition, right? Now let's say one of the parties is Indian and another party is foreigner. Then this could be a case of international commercial arbitration as per 21F, because that is what is required. At least one of the parties is international. Now let's say both the parties are not Indians, both the parties are foreigners. then again, as per the definition of 21F, it would again be an international commercial arbitration. Why? Because both, at least one of the parties, the requirement is that at least one of the parties should be foreigner, right? So it would also include an example of wherein both the parties are foreigners. All right, let's discuss certain cases, right? And let's see if we're able to interpret this term uh, accordingly in part one. Remember, part one was where arbitration is seated in India. Now let's read the examples. Now, the first example is Reliance Limited, incorporated in India, and Star Private Limited, incorporated in India, but centrally managed in Malaysia, right? And by centrally managed, we could mean that the directors sit in Malaysia, they're taking all the major decisions from Malaysia, perhaps the board meeting are being undertaken in Malaysia, so on and so forth. So these two companies entered into a contract, and the contract contains arbitration clause, and seat is in Bombay. So first things first, we have to figure out whether part one applies. That's our first thing that we'll figure out. And second thing that we'll do is, in this exercise, we will figure out if this is the case of international commercial arbitration, which is section 21F. So, does part 1 apply here? The answer should be yes. Why? Because the seat is in Bombay, which is in India. So, part 1 applies. Now that part 1 applies, the definition of ICA as per 21F would be applicable. Right? Because why? Because section 2 says in this part, ICA is defined as follows. So this definition is specific to part 1 only, right? So now that we have established part 1 is applicable, now we can say, see if it is an ICA as per part 1's requirement, which is 21F. So it says we have two companies, Reliance Incorporated in India, Star Private Limited, incorporated in India but managed outside. Now let's see under which heading we would follow. So since we're talking about companies, hence companies are body corporate, right? For instance, a limited liability partnership would also be body corporate, right? Why? Because once you've registered it under the Act, as per the Act, the Companies Act, the LLP Act, they become a body corporate or a person of their own, a legal entity. A legal fiction is created by the virtue of which they become a legal entity in the eyes of law. And that is what we mean by a body corporate. So it says that in case of a body corporate or in cases of a company which is incorporated in any other country other than India. So in order for our definition, in order for our first case to qualify for an ICA, at least one of these parties, either Reliance or Star Private Limited, both of them being body corporates, at least one of them should have been incorporated outside India, right? Which is not the case here. And it seems like from the definition that central management of the body corporate doesn't matter. So the only thing that would matter in cases of a body corporate is where their place of incorporation is. And if that is in India, that would make them Indian parties as per this definition, right? Because the and we're getting to that conclusion by negating what part two, uh, uh, what point number two here provides us, which is body corporate incorporated in any other country than India, right? Here, guys, you should take note of the TDM infrastructure case. Hmm. The facts of the case were similar to the first point here, wherein the company TDM Infrastructure was incorporated in India but centrally managed from Malaysia. And at that point, this definition looked a bit different. So the three stars that you see after point number three, this actually included the phrase company, and which has now been removed after the amendment. So it is this case wherein the Supreme Court held that when it comes to the companies, central management perhaps is not that important. The incorporation place is more important. And if that incorporation place is in India, then that's an Indian party at the end of the day, right? So herein, both companies incorporated in India, hence both companies are Indian parties. There's no international character. So this is not an ICA. Let's see second point. Miss Annie, Indian citizen residing in India, and Wind Farm LLP, incorporated in India, entered into a contract. The contract contains arbitration clause and seat is in Bombay. Does part 1 apply? I hope your answer is yes, since it's in India. It's an Indian seated arbitration. Is it an ICA as per part 1's definition? So let's see. Annie is an individual, and the requirement is if an individual has a foreign nationality or is habitually resident of a foreign country. And Annie here is none of that. She's an Indian citizen residing in India. So she's an Indian party. Wind Farm LLP. So it's a limited liability partnership, again, a body corporate, incorporated in India. We don't know about the management, doesn't matter. For body corporates, only incorporation matters. It's in India. So both parties here are Indian. So it's not an ICA. Let's go to point number 3. Vodafone PLC and Government of India arbitrated, entered into a commercial contract which contained an arbitration clause. Now, here, especially those of you who are company law students, you would appreciate the suffixes that are used in company's name. And when it's limited or it's private limited or it's OPC, that might give us a hint that it might be incorporated in India because those are the suffixes we used in our jurisdiction. But when the suffix is, let's say, PLC, you should know right away that it's not a company incorporated in India, right? UK perhaps does use this suffix. So it's an company incorporated outside India, right? Because if it would have been an Indian incorporated company, PLC would not have been the suffix, and it's the government of India, which is the party. The seat is in Hague, Netherlands. So now let's answer this question. So does part 1 apply here? The answer should be no, because the seat is the Hague, Netherlands. For part 1, the seat should be in India. So part 1 does not apply here. Part 2 applies here. Right? So now, how do we figure out if it's an international commercial arbitration? Should we apply definition of 21F to part 2 as well? The answer should be no here. So we will not apply this definition as is. In the second leg of this video, we would figure out then how to define ICA if it's not by the application of 21F, right? Had this been part 1, guys, so had the seat been in India, what would have been the answer? I hope the answer would have been that it is an ICA because Vodafone is a foreign company. Miss Annie, Indian citizen habitually residing outside India. So now she's an Indian citizen, but habitually residing outside India. Disqualifies her for point number 1 here, which is individual who is national of or habitually residing in a country other than India. She is residing outside of India. And wind farm partnership firm, centrally managed from outside India. Note that it's a partnership firm, hence not a body corporate. So for those which are not body corporates, even if their central management is outside India, that qualifies, that gives them that international character, right? So both the parties here have international character, and hence, as per Part 1 at least, they should be an international commercial arbitration. But we would hold on to that. Why? Because the seat here is Singapore. So Part 1 doesn't apply. So we will not contemplate it as per the definition of 21F. We will hold that question to ourselves that how are we defining ICA in Part 2, right? But again, had this been Part 1, what would have been the answer? I hope your answer would have been that both the parties are international, have that international character here as per the definition. Therefore, it is an international commercial arbitration only if the seat was in India. All right. PASL Wind Solution incorporated in India. GE Power Private Limited incorporated in India. Both the companies, both are body corporates. Hence, incorporation matters. As per point 2, they're incorporated in India. So both Indian parties. Seat is in Zurich. So part 1 doesn't apply, part 2 applies. Right? Both are Indian parties. Had this been in India, would this be an ICA? Would this be a case of international commercial arbitration? I hope your answer is no there because both the parties are Indian. But the seat is not in India, and hence we will not apply Section 21F to the definition. So we'll again hold the question, how are we defining international commercial arbitration in Part 2, right? Perfect. But I hope your understanding of defining international commercial arbitration in Part 1 is clear, right? Now, what are the few takeaways from Part 1? Part 1 definition is party-centric definition. When your arbitrations are seated in India, the way we are characterizing an international commercial arbitration is by figuring out whether there is an international element to any of the parties to the arbitration. And if there is, then it would be a case of international commercial arbitration. And that international element is judged separately. So we are told by the definition how to judge that international element. For instance, in case of an individual, we will check their nationality and their residence. In case of a body corporate, company, LLP, etc., we would check their place of incorporation. In case of a body of individual or association, we would check their central management. And in case of government, we'll see which are they Indian government or not, right? So it's a very party-centric definition that we apply to arbitration seated in India. Now we come to the second leg of our issue. How do we define international commercial arbitration under Part 2 of the Act? And I've already discussed briefly with you guys as to how Part 2 contains two chapters and sort of imbibes two conventions, which is New York Convention and Geneva Convention, for enforcement or rather recognition and enforcement of foreign awards. Now, an interesting point to be noted. So, firstly, we will look into part two itself. Has international commercial arbitration been defined anywhere in part two? An answer to that would be a clear no. So you wouldn't find any definition clause per se for part two. Then we see, all right, there is no definition clause in part two, specifically in chapter one. We are only focusing our discussions around chapter one because that is what is used and what is effective. Now, chapter two is essentially redundant. I perhaps will discuss that in another video sometime. So now let's see, all right, there's no definition clause specifically defining international commercial arbitration. Another interesting thing that you must notice is the phrase international commercial arbitration used anywhere in part 2? So when you will look at part 2 of the ANC Act, as you can see before the screens, you will essentially find that nowhere in the provisions do we find the phrase international commercial arbitration, right? And the phrase that we find in this chapter 1, which gives effect to New York Convention provision, is essentially arbitration, right? So, be it section 44, wherein you can see, let me see if I can uh, highlight it for you guys on the screen. Apparently, I'm unable to do that. Never mind. So, when you see, let's say, for instance, section 44 in subclause A, you'll find the phrase arbitration. In section 45, again, you will find the phrase arbitration in the second last line, and you will not find international commercial arbitration being used anywhere. I hope that makes sense. So, the first in the first inquiry as to how do we define international commercial arbitration under part 2, in the first inquiry we find, all right, there is no particular definition clause in part 2 which provides such definition. Secondly, there's not even any phrase which particularly says international commercial arbitration under part 2. And why is this important for us? Had there been a phrase international commercial arbitration, then perhaps there would have been necessity to look at the definition clause, right? Now hold on to that explanation because we will come back to that explanation in a second. Now, in the case of PASL win solution, I've given the citation on the screen. I will try to give links to the judgment in the description as well. It's a three-judge Supreme Court bench case, and essentially the facts of this case are there were two parties, both Indian, essentially arbitrating abroad in Zurich. And the wider question that Supreme Court was answering here was, is this going to be an arbitration in part 1, or is this going to be an arbitration in part 2 of the ANC Act? In other words, Supreme Court was also answering the question whether two Indian parties can go abroad and arbitrate, right? Now, one of the arguments to negate uh, or to stop this arbitration to be qualified under part 2, one of the argument was that part 2 only is applicable on international commercial arbitrations as defined under Section 2(1)(f), right? So the main one of the main contentions was that Part 2 of the ANC Act would only be would only be applicable to foreign seated international commercial arbitrations, and these international commercial arbitrations would be as defined in Section 2(1)(f), right? All right. Now, how did the Supreme Court contemplate this argument or tested this argument essentially? So, first things first, the Supreme Court clarified that look, Section 2(1)(f) would not be applicable per se on Part 2 because the definition clause is only restricted to Part 1, right? So that's that. The second thing that Supreme Court noted was, as we have already established that 2(1)(f) is a party-centric definition, the Supreme Court established that Part 2, which gives effect to New York Convention provisions, which is this Chapter 1, this chapter is essentially place-centric. What does this mean? We can get this from Section 44 of the Act as well. So when you read Section 44, it says, in this chapter, unless otherwise the context provides, foreign award means an arbitral award on the differences between persons arising out of legal relationships, whether contractual or not, considered as commercial under the law in force in India. So, foreign award is essentially an award arising out of a commercial dispute which was subjected to arbitration, and in pursuance of an agreement to which the convention, which is the New York Convention, applies. So basically, it's an arbitration under an agreement to which New York Convention applies. And this arbitration is in one of such territories as the central government, being satisfied that reciprocal provisions have been made may by notification of the official gazette declare to be territories to which said convention applies. So, what is the applicability of Part 2? So Part 2 will apply to the arbitrations arising out of arbitrations agreement to which New York Convention applies, and arbitrations which were held or seated in the places where New York Convention applies, or where India has made reciprocal promises with respect to those places. For instance, the seat is in US. And while signing New York Convention, India basically said that this is a reciprocal promise. So every country which is offering me or which is going to enforce foreign awards arising out of India, I am going to enforce foreign awards arising out of their territories. So this is a reciprocal arrangement that India has entered into while signing the New York Convention. Now, what you must appreciate out of this is that all of this arrangement is place-centric. Now, what do we mean by that? So it means when India signed New York Convention, and the provisions of New York Conventions are also laid in the same manner, the promise essentially is that India will honor New York Convention or apply the provisions, or in simpler words, will enforce the foreign award arising out of that place where to which the reciprocal promises are promised. So all that matters in enforcement of this foreign award is the place from which this arbitration is happening or place from which this award is arising out of. There is no mention of the nationality of the parties or whether the parties also need to be residents of or natural citizens of those New York Convention signatory countries. The only requirement is that no matter who the party is, the party could be Indian, the party could be another New York Convention country's national, the party could be a third country's national who is not a citizen of New York Convention country. Doesn't matter the nationality. Whoever the parties are, if they have conducted their arbitration in one of the New York Convention signatory countries, India will enforce its foreign award under Part 2 of the ANC Act. That's the promise that we have made. Hence, making this entire arrangement a place-centric arrangement rather than a party-centric arrangement. Again, why is that? Because nationality of the parties would not affect the the applicability of the provisions. I hope that makes sense. All right. So 2 and F is party centric, wherein part 2 provisions of NYC, part 2 provisions of NYC, which is in chapter 1, is essentially place centric. Right? So this was the second observation which was done by the courts. Now that we've figured out, so as soon as the courts identified that, look, chapter 1, uh, giving effect to New York Convention, those provisions, the arbitration that we are referring to is is to be interpreted from a place-centric definition. So the only thing that we are concerned about is what's the place of the arbitration, and when we'll try to define international commercial arbitration into it, in this part 2, we have to look at it from a place-centric point of view, right? Now, another thing that we identified and we figured was there is no phrase that is international commercial arbitration, which is used in this part 2. Essentially, the only phrase used is arbitration. And that arbitration, as Supreme Court first noticed, should be from a place-centric view. So that arbitration essentially means, so arbitration referred to in part 2 essentially means a foreign seated arbitration. Right? So if you remember the entire issue in PASL, which was there were two Indian parties arbitrating in Zurich. The main argument was part 2 only provides for international commercial arbitrations. So the first negating argument to negate that contention is essentially part 2 is a place, provides a place-centric approach to defining arbitration itself, right? Secondly, there is no international commercial arbitration phrase in part 2. Now, there are two places which provides international commercial arbitration in reference to part 2. And these two places are Section 2, subsection 2 of the ANC Act and Section 10, subsection 1 of the Commercial Courts Act. So these are the two places wherein the law, the legal text provides the phrase or the term international commercial arbitration in relation to Part 2. So now it becomes essential for us to define international commercial arbitration. And now the question arises, are we defining it as per 21F or we need to give it a new definition? So let's see what Section 2, subsection 2 says. Firstly, this section lies in Part 1. Let's read this section. It says this part, which is essentially Part 1, that's where this section lies, shall apply where place of arbitration is in India. Right? A very straightforward provision saying this part, Part 1, would apply to arbitrations in India. We have already established this. Proviso. A note, an interesting note, that this proviso was added in the 2015 amendment to dilute the effect of Balco's ratio, right? So uh, we'll perhaps discuss it in another video. All right, now what does this proviso say? It says, provided that subject to an agreement to contrary, the provisions of Section 927 and 27 1B and 37 subsection 3 shall also apply. Now comes the important part. To international commercial arbitration, even if place of arbitration is outside India, an arbitral award made to be or made in such places is enforceable and recognized under Part 2 of this Act. Now, what is happening here? Here, the legal text is giving us the term ICA. So this provision is applicable to international commercial arbitrations, foreign seated international commercial arbitrations, to which Part 2 applies. Right? What we have established so far is Part 2 does not have any definition clause, and international commercial arbitration is not found in Part 2 at all. Part 2's view, the portion of Part 2 which uh, uh, sort of brings in New York Convention text is a place, comes from a place-centric point of view. So now, when this proviso says international commercial arbitration under Part 2, now we need to define international commercial arbitration. And remember, this proviso lies in Part 1, right? And how do we define international commercial arbitration in Part 1? Section 21F. Correct? So, but Supreme Court here said we are not going to define international commercial arbitration as per Section 21F. Why? Because we are going to utilize the phrase unless the context otherwise requires. Unless the context otherwise requires, international commercial arbitration shall be defined like this. And Supreme Court here said that here when we use international commercial arbitration under Part 2, it does fall under unless the context otherwise require. And why so? Because here this international commercial arbitration is it with respect to Part 2. We have already established that Part 2 has a place-centric view and not a party-centric view. Therefore, we are not going to use the definition in 21F, but we are going to use another meaning to this. And Supreme Court said that how we'll define this international commercial arbitration here is from a place-centric view, and we rather call it international commercial arbitration, right? And what does that mean? The focus of international term would be on the place and not on the international character of the parties. So no matter what the nationality of the parties is, if the place of arbitration is outside India, that is international commercial arbitration. So how are we distinguishing in the two definitions? When we are defining international commercial arbitration in part 1, we are defining it as per 21F, a party-centric definition. One of the parties should have international character. And when we are defining this term under part 2, we are defining it from a place-centric point of view, no matter what the nationality of the parties is. As long as it is outside India, it is international commercial arbitration, right? Another place where international commercial arbitration is used is Section 10 of the Commercial Courts Act. Basically establishes and provides provisions laying down jurisdiction of the commercial courts. An arbitration matter being commercial matters at the end of the day would essentially end up before such a court. So Section 10 lays down jurisdiction in respect of arbitration matters. And Section 10, subsection 1 provides arbitration is an international commercial arbitration. All applications or appeals arising out of such arbitrations under the provisions of ANC Act shall have been filed in a high court, shall heard and be disposed of by commercial division, where such commercial division has been constituted in such high court. Now, when you see the usage of the term international commercial arbitration, it is used generally with Arbitration and Conciliations Act, right? So basically, this subsection says if there is an international commercial arbitration under the ANC Act, the jurisdiction would be with uh, uh, the High Court, the commercial division constituted in such a High Court, right? But the point to be noted here is we'll have to look at international commercial arbitrations under Part 1 and Part 2 separately because we have already established how these two are to be defined separately. Now, for Part 1, defining international commercial arbitration is easy to 1F, but for Part 2 here, the Supreme Court again took the same rationale as taken for the previous section, which is 2 subsection 2. Supreme Court said that Part 2 is again adopts a place-centric approach to arbitration. And when we read this provision essentially with Section 47 in Part 2, which gives us a hint about jurisdiction of the courts, to which court we will file Part 2 applications uh, at. It says in this subsection, the court means High Court. In this subsection and section following in this chapter, the court means High Court having original jurisdiction to decide questions forming the subject matter of the arbitral award, if same has been the subject matter of the suit on its original civil jurisdiction and in other cases. In case High Court having jurisdiction to hear appeals from decrees of courts subordinate to such High Court. So essentially, it says that matter would go to High Court, and Supreme Court said that there is no contradiction between the two. Section 10, subsection 1 also gives jurisdiction to the high courts, to the commercial division established within such high courts, and so does Section 47. It refers the matters uh, to the high courts. So, Supreme Court said, which means essentially that when we are contemplating in or when we are defining international commercial arbitration, even under Section 10, subsection 1 of the Commercial Courts Act, with the place-centric approach, it doesn't contradict with any of the provision, right? So even here, while defining ICA with respect to Part 2, we can simply define it from a place-centric approach, which essentially means no matter what the nationality of the parties is, uh, if the seat is outside, that's international commercial arbitration. All right, so final takeaways from this video. I guess this chart would be a good chart for the final takeaway. So, how do we define international commercial arbitration? In part one, it is when we are in part one, that is our seat is in India, we simply refer to 21F, which gives us a party-centric approach to defining international commercial arbitration. One of the parties to the arbitration should have international or foreign character. When we are in part two, which is our arbitration is seated outside India, then we must note that 21F would not be of resort to us. ICA phrase is essentially not used in part two anywhere. The point of view, the term used is arbitration, and that arbitration uh, comes from a place-centric approach rather than a party-centric approach. The two places where ICA is mentioned in context of Part 2 is Section 2, subsection 2 in ANC Act and Section 10, subsection 1 of the Commercial Courts Act. And the courts in both these sections, while interpreting them, have held that we will define international commercial arbitration from a place-centric approach, which means no matter what the nationality of the parties is, as long as arbitration is seated outside India, it is international commercial arbitration. I hope this video helped you guys. Thank you so much.